I am Professor V. Keshav Rao, Professor of Law, National University Odisha at Cuttack. I will be talking on the topic A Conspectus of Jurisprudence. It is an overview, not the overview of jurisprudence. The learning objectives of this particular lesson are: number 1, to provide an overview of jurisprudence, to present different perspectives on jurisprudence, to pinpoint its aims and uses, to portray its evolution, to preview its relations with other social sciences and its homogeneity as a subject, and to point out the concerns of jurisprudence. We all know that jurisprudence is an English word derived from the Latin word jurisprudentia, which has two distinct words, jure or juris, meaning law or legal, and prudentia, skill or knowledge. Therefore, jurisprudence is knowledge of law. When we talk of knowledge of law, it is not knowledge of statutory provisions or judicial decisions. Mere such knowledge is not the conspectus of jurisprudence. Then the question arises, what is the conspectus of jurisprudence? The conspectus of jurisprudence was laid and relayed by many jurists approaching the subject from different perspectives. Conspectus of the subject is such that laying down with precision its scope is impossible. It is not mere knowledge of the principles of law, it is more than mere knowledge of principles of law. It ascertains the fundamental principles of which law is concerned. It deals with the foundation and not with the superstructure of law or the edifice of law. It is the basis on which the superstructure or the edifice of law is built. The meaning of the term jurisprudence is confusing because it was used in different senses. It is more confounded by the use of the word in different contexts. For example, we come across the phrase equity jurisprudence. Well, actually, equity jurisprudence is the name of a treatise upon the law administered by the courts of equity. Similarly, we have medical jurisprudence. It is also the name of a treatise or a book upon medical facts important in legal proceedings. Similarly, there is another expression, ophthalmic jurisprudence, that is the title of a book on ophthalmic branch of medicine. Similarly, we are familiar with the expression Hindu jurisprudence, indicating the body of law governing Hindus. Dental jurisprudence is the name of a chair in the Dental School of Chicago. Well, despite the ways in which it is used, the word is defined. It is defined by many from different perspectives. Let us consider them one by one. The term has been used in different ways as it is indicated in this diagram. We will go into the details. The first is jurisprudence as a science. That is, science we all know is a verifiable truth. Science is a systematic body of knowledge. It is said by Allen that scientific synthesis of the essential principles of law is what is meant by jurisprudence. Holland calls it the formal science of positive law, and whereas Gray gave a very detailed account of jurisprudence as a science by commenting, I quote, "The science of law, the statement and systematic arrangement of the rules followed by the courts and the principles involved in those rules." There are other jurists who also expressed similar opinions on jurisprudence as a science. For example, Beale, he calls it jurisprudence is the science of justice, whereas Clark names it as the science of law in general. Salmon, the greatest jurisprudentialist, he calls it as the science of first principles of civil law. Well, the end of jurisprudence is the same as that of all sciences in general. The second important approach to define jurisprudence is from knowledge perspective. The knowledge of things, human and divine, the science of the just and unjust, is jurisprudence according to Ulpian. A particular method of study, not the law of one country, but of the general notions of law itself, is the opinion expressed by Patton. The lawyer's extraversion is jurisprudence. It is the lawyer's examination of the principles, precepts, ideas and techniques of the law in the light derived from the present knowledge in disciplines other than the law. That is the wonderful definition given by Stone. In other words, the study relating to law is the subject of jurisprudence, and it is the knowledge of law that one is going to acquire by studying the subject. The third important dimension is jurisprudence and law. Jurisprudence was described as the harp that produces the melody of law. Law always plays on the strings of that harp. It was said by Chetna that jurisprudence is the harp that produces the melody of law, for the legislators, judges and lawyers are the musicians who play and sing on the strings. It is described as the eye of law and the grammar of law. It being the eye of law, it provides the vision as to what is law by dealing with all its fundamental aspects and precepts. What is the aim of jurisprudence is the next subtopic we have to consider. It is a complete grasp, a systematic penetration of its subject matter. The power of following the most general propositions into their minutest ramifications, and inversely of ascending from the most concrete case through all intermediate stages of thought to the principle which governs it. This is the description of the aim of jurisprudence as given by Mr. Moyle, whereas Mr. Vinograph argues that in contrast to the simple rules and divisions of positive law which strike across the history of all nations, there arises a science of law, a jurisprudence which aims at discovering the general principles underlying the legal enactments and judicial decisions. I repeat, the general principles underlying legal enactments and judicial decisions, because the purpose of jurisprudence is to provide an insight into the basis of foundations of legal principles and an analysis of legal concepts. Law deals with rules evolved out of that basis or foundation. It does not deal with rules itself. It only lays down the rules from which evolved the foundation. Now, let us see the uses of jurisprudence. Well, jurisprudence has many uses. The first important use is it gives an understanding of nature of law. It helps in tracing the underlying principles of law. It also develops the critical faculties of the legal perception. It enables proper comprehension of legal expression and terminology. It virtually fosters the link between law and other disciplines. The evolution of jurisprudence is the next topic we have to consider. It can be divided into three periods: pre-Roman period, Roman period and post-Roman period. We will start with the pre-Roman period. In pre-Roman period, jurisprudence as a distinct science and a subject of knowledge was virtually ignored, because during pre-Roman period all science is one universal. No coherent and separate discipline called law was there, because law was considered as part and parcel of all human activities. Pre-Roman period, which was totally dominated by and influenced by the Greek intellect with all its mobility and elasticity, was quite unable to confine itself within the straight waistcoat of a legal formula. This was a cryptic observation of Maine. Questions of pure law were constantly argued on every consideration which could influence the mind of the judges. Roman period. From the pre-Roman period, when we come to the Roman period, there is a distinct change. For the beginning of science which reduces legal phenomena to order and coherence, the world is indebted to the Romans. It is also from their language that the science derives its name according to Holland. The Romans have laid the foundations of modern analytical jurisprudence, but their contribution to legal philosophy has been slight according to Friedman. This is actually not a recognition of Romans' contribution. Despite this criticism, it is actually during the Roman period that the idea took its base, and from there, when we come to the post-Roman period, in the 16th century, we find emancipation of legal science from the shackles of theology began. In the 19th century, it started gaining importance and grew as an independent science, and Bentham has observed that it has weaned itself from the juridical science out of theological doctrines. This is for the first time we find that theology which has subsumed the subject of juridical science for a long time, from its shackles, and basing on this we can say that the modern jurisprudence thus trenches on the field of the social sciences and of philosophy. It digs into the historical past and attempts to create the symmetry of a garden out of the luxurious chaos of conflicting legal systems according to pattern, and ultimately it emerged and grew as an important subject. Hindu jurisprudence is India's contribution. Thus evolved, the jurisprudence has to be distinguished from other social sciences that are prevalent. Jurisprudence, because it deals with the lives of human beings, the interactions of human beings, and the deeds of human beings, is undoubtedly human science. Its conspectus is better appreciated conjointly with other social sciences. Let us proceed to see how jurisprudence is linked or related or connected with other social sciences. In this picture you will see that all other sciences are combining themselves to come out as a single subject of jurisprudence. Actually, once it is connected with all subjects, then the question arises, what are the jurisprudential concerns? Its main concern is what is law? What are the sources of law? Well, what is law is not a very simple question, though the question appears to be very simple. Lot of answers have been given. From poets to politicians, this question has been asked, and it has been approached from different perspectives, from different angles, and unless one is sure as to what is law, one will not be able to really understand the scope and purpose of law. Therefore, the basic question is what is law and what are the sources of law. When we ask the question what is law, we are not asking the question what is the law governing a particular field of activity, a particular human activity, but we are in general talking at the abstract level as to what is law and what are the sources of law. Once we are clear about what is law and what are the sources of law, what are the schools of law? School of law is consisting of a few thinkers on the same line. When a few legal pundits think and define what is law from one perspective, all of them who share the same perspective said to belong to a school of law. What are the different schools that approached the study of law and attempted to define law is one thing which we have to consider. What are the concepts of law? Well, in this paper, you are going to study the basic concepts of law on which the entire edifice is built. and ultimately we have to understand, if we have to have a fair idea as to what is the purpose of jurisprudence, as to what is the ideal law, what is the end of law, and the what and how of justice. Unless we have an overview, not the overview of this entire gamut of subject, we cannot say that our study of jurisprudence has started in a proper way. When we think of law as its end and understand what is the end of law, we can simply say the think tank of what, why and how of law is jurisprudence. What are the different perceptions as to what is law? What are the different purposes of law as envisaged? What are the different disquisitions by jurists from time to time as to the ideal of law or ideal law, and what are the different approaches to justice is what is expected of us to know. I have placed before you that a school of law is a combination of thinking by different scholars in one perspective. When many scholars try to look at law and define law from one angle or from one perspective or from one point of view, we say they all belong to a school of law. We actually find 6 different schools of thought today. The first one, not in the order of evolution, but generally we say it is philosophical school, natural law school, historical school, sociological school, economic school and realist school. Philosophical school is looking at what is law, what is the purpose of law, what is the ideal of law from a philosophical perspective. Philosophy was the subject, and there are many scholars who try to define what is law, keeping in mind the philosophical developments. The second one is natural law. There are several jurists who considered natural law from the point of the gradual evolution of nature and thought. For them, certain things automatically happen, and a law to get approval and obedience from the society must be in tune with those natural principles. Then historical law, they believe in the simple philosophy or policy that today is a gradual projection of the past and tomorrow would be a gradual projection of the present. Therefore, historically how the law has evolved must be understood to make a foray into what is going to happen in future. Then the sociological school of thought links the law from the society point of view where it is applied. Hence, they always try to say that law is to be approached from the sociological perspective. Then in this modern materialistic world, economic school, especially led by Marx and others, they say that law can be approached from study of the economics. The economic analysis of law is a wonderful concept which has emanated from the economic school of thought. And lastly, the realist. What is said in the statute, what happened in the past, what is the ideal is to be distinguished from what is actually happening in the society. What is actually happening in the society being the reality, law has to be understood, defined and progressed only from the realist school. The American realist school is responsible for this school of thought. Thus, we can at least discern 6 different schools of thought as to what law is. From these 6 different schools, there are certain fundamental legal concepts. For example, we use the expression right, we use the expression liability, we use the expression crime, we use the expression contract, we use the expression possession, we commonly use the expression title, ownership. Is there no distinction between them? What is the specific conspectus of each and every one of these legal concepts? These have to be understood by us, and these form part of the subject of jurisprudence. Therefore, a conspectus of jurisprudence involves normally not only what is the school of law, what is the end of law, what is the definition of law. It also includes what are the basic legal concepts. A knowledge of all of them would definitely help us in understanding the subject better. Therefore, anyone who is venturing into study the jurisprudence must have some basic idea, and that basic idea constitutes the preview, and therefore, this overview gives to the student that preview as to know what is it he is going to read. We will start with the sources of law. Basically, the three basic sources are the custom, the precedent and legislation. When would a custom be considered as a source of law? What are the kinds of precedents that can be discerned from the judgment? What is the value of these different kinds of precedents? What is the value to be attached to a precedent? When a precedent can be ignored and a new proposition of law can be laid down. And legislation, the greatest source of law in the modern world. What are their merits? What are their demerits? What is the role and what is the reality? Unless we have an overview of them, well, our understanding of those subjects, especially the gamut of jurisprudence, will be very difficult. So, the merits and demerits, role and responsibility of the custom, of the precedent, of the legislation is what is expected to be known by us. Then we come to the schools of law, schools of thought on law from different paradigms. Natural law school, some people try to define what is law from the natural evolution, others from a philosophical perspective, third from historical perspective. Then because the law is concerned with society, the sociological perspective. In this modern materialistic world, from economic perspective, and ultimately there is a school of thought which says law is ultimately governed and decides, therefore, jurisprudence must relate itself to the realist school. Legal concepts, their import, their innovation and their inquisition is what is expected to be known by us. And the concepts, in the A conspectus to the conspectus, we find Western ostentations to Indian orientations, uncertainty to definiteness. Is it possible? Is it plausible? Is the conspectus. But can we reach the conspectus without having an idea about A conspectus? This initial lecture is not to place before the student the conspectus of jurisprudence. It is only meant for placing before the student a conspectus of jurisprudence. A conspectus of jurisprudence is one way of looking at the subject of jurisprudence, one way of looking at the scope of jurisprudence, one way of looking at the overview of the subject of jurisprudence before actually the student embarks upon the study of jurisprudence. Any subject, once we start studying, we must have a preview. That preview is provided by this particular module, and from this preview, before you actually venture into studying the different facets of the subject, it will better understanding for you if you keep in mind that this is exactly what I am going to study by reading the subject called jurisprudence. What is it exactly you are going to study is the purpose of this particular lesson. Its objectives are very simple. It is not to tell you what is jurisprudence. It is not even to tell you what is law. The purpose of this particular presentation or talk is just meant to give you an overview, one of the different varieties of overviews that can be given for anyone that ventures into understand and study and understand the subject of jurisprudence. That is why it is deliberately titled A Conspectus of Jurisprudence and not The Conspectus. The Conspectus presupposes that there is only an overview. A Conspectus proposes that there are many ways of looking at it, and this is one way of looking at the subject. Therefore, dear listeners, welcome to this A Conspectus of the Jurisprudence. so that from a conspectus your journey will be towards the conspectus of jurisprudence. And lot of western ostentations are given to this word jurisprudence. How we can bring the Indian orientation to the western ostentations, keeping in mind our rich heritage of Hindu jurisprudence. It appears to be uncertain, because the jurisprudence being an evolving subject, it is always uncertain. From uncertainty, can we come to any definiteness? Can we formulate a definite idea about the different schools, about the different conceptions, about the different concepts? Well, all these are undoubtedly part and parcel of the subject, and I am sure you will definitely take a leaf from this. Keep this in mind before you actually venture into the subject study, the subject, wonderful subject, a fascinating subject, the basic subject which gives you the real basis of the entire gamut of law. The subject is jurisprudence. You have gone through a conspectus of jurisprudence. Now please go through the jurisprudence and become a legally knowledgeable person. Wish you all the best. Thank you.